deny Osprey Healthcare Center's motion to compel arbitration in this case was error and should be corrected by this court. The court, lower court, as a result of apparently of the deluge of arguments by opposing counsel, appears to have lost sight of the fact that the arbitration agreement we have in front of us is an enforceable arbitration agreement. It very clearly expresses the intent of the parties to arbitrate any disputes between them. It does not contain any remedial limitations, at least that is our position. To the extent the court disagrees with our position that any of the provisions that plaintiff made reference to were remedial provisions, those provisions could and should have been severed pursuant to the controlling case law to give effect to the intent of the parties and the strong public policy in the state in favor of arbitration. Now,
Mr. Brown, there's a question that's on my mind. One of the arguments that you both have argued extensively is about the statute of limitations provision. And I understand your argument that it could be severed. But let me ask you this. If you are you're the party to this agreement and you think you may have a claim that you want to bring, you haven't done it yet, and you take a look at this and you see this provision that says you have a year to do it. Well, it's been a year and 6 months. So you're like, oh, well, I guess I'm out of luck. So severability doesn't cure that issue. So can you speak to that?
Well, Your Honor, in this case, that's that issue ends up being irrelevant because this claim was filed within the 1 year statute of limitations. But
no, I understand. So you're saying whether or not a provision is against public policy, it depends on whether it actually caused any harm in a particular case?
No, Your Honor, it's a two-pronged argument, really. It's that it's not relevant and doesn't provide a basis for invalidating.
Well, I mean, I understand I understand your argument, and I think that provision is just void at the outset because of a statute, right? Isn't it statutorily invalidated?
That's correct.
But a person that signed this, entered into it, and is reading it, that's not a lawyer and is trying to decide what they should do. They think they have a claim, and it's been more than a year. Why, isn't that misleading?
Well, Your Honor, it's difficult to speculate about what a person may do. We have litigated a number of cases and before this court and others where similar type arguments have been made. Remedial limitations have been in place that may have misled a person who wasn't represented by counsel. But all we can deal with is the case that's before the court. And if the court views this provision the way it viewed remedial limitations in cases like Tesorario, the case decided around about a year ago, if it finds that this provision is void, the provision should be stricken to save the arbitration agreement. I think there's a possibility. I can see what Your Honor is saying, that someone might be misled by that, but that's not a concrete basis for overturning the arbitration agreement between these individuals here. Certainly, severance of the provision is warranted under the controlling law to give effect to the intent of the parties here. But speculating about what someone might or might not do, to the extent they brought a case to Wilkes and Associates or another law firm to have them look at it, they would challenge it. And we've been in front of this court numerous times in cases where those types of challenges have been made and where the court has found that the contract contained void provisions. It has routinely severed them to uphold arbitration in cases where there's agreement, there's a severability clause like this one.
Well, I just raised this question because, I will say my initial reaction was, yeah, of course you can sever this. I mean, I didn't really, I was on board with that argument, but then on reflection, I started thinking about it. I'm like, well, that really wouldn't cure it to the extent that having a provision in a contract like this might be prejudicial to someone considering bringing a claim. And would that be a basis to invalidate it? And I understand that your answer is no, because that's speculative.
It is speculative, Your Honor. And in this case, even if the plaintiff hadn't filed within the 1 year and they had brought this case, then the argument would be the same. It would be, if you consider this provision to be void, then it should be severed, just as numerous other remedial provisions have been severed, because really the argument you're making could be made in any case where there's remedial limitations. Well, if they're going to cap my damages, or if I'm going to have to share costs, I may as well.
I'm not sure I agree with that, because I don't know that would preclude someone from bringing a claim. And I mean, I'm talking about someone reads this and says, I'm out of luck, I'm done. As opposed to, oh, well, maybe I can't get this or that, but let me see what I can get, which is how I would read a remedial limitation. And I guess then I would reiterate what I think your Honor understands my argument then, that it's speculative what someone might do. In this case, that didn't happen. And if the statute of limitations had been
the lawsuit in this case was filed within the 1 year, was it not?
It was, Your Honor. It was filed.
So I'm not sure. Maybe you'd like to address whether we could even reverse on the ground that Judge Kelly brings up, since it doesn't really apply in this case. I don't know the answer to that question, but you probably want to talk to her about that.
Well, Your Honor, I don't think that the court can reverse on that basis, because that's taking a provision that is.
I was thinking more a basis to affirm, but. It was a matter of curiosity to me, because really no one addressed it, which maybe means that it's just a matter of curiosity to me. But severing does not cure that problem, that you have a provision in here that might prevent someone from ever looking into whether they can pursue their claim.
In a hypothetical case with that hypothetical plaintiff, I think Your Honor would be right if that person didn't go to an attorney. In this case, or in any other case where a person went to an attorney and had either filed within the 1 year, as Ms. Outwater did on behalf of Ms. Piscazzi here, or filed after the 1 year and brought this up, we would be making the same argument that severability should be employed to save the arbitration agreement, because the intent of these parties is to arbitrate.
Mr. Valdez, am I remembering correctly that in Roman numeral 8 of the arbitration agreement, where there's a reference of where the claims can be filed, Osprey Healthcare Center, Inc., that there was some problem with the directive as to where the claim should be filed? Am I remembering that correctly?
Yes, Your Honor. Opposing counsel, although Osprey Healthcare Center is referred to throughout the arbitration agreement, and the arbitration agreement says that any affiliates, business entities affiliated, or employees are governed by the agreement. In paragraph 8, there's a sentence that says, to initiate the arbitration process, the aggrieved party must file a written claim. Claims can, and that's permissive, can be filed with the office of Osprey Healthcare Center, Inc. Now, it's our position that that's a clerical error. Nowhere is there is no Osprey Healthcare Center, Inc. It's Osprey Healthcare Center, LLC. It's permissive in that it says it can be a copy can be filed with them. And it's very clearly referring to the same Osprey Health that's referred to throughout.
I don't know, maybe not, but let me ask you along those lines. I want to follow up a little bit differently on that. One of the arguments that they've made is that a valid agreement was never formed because it's missing essential terms. This would be part of that. As I understand your argument, your response to that argument is, well, the Florida Arbitration Code could fill in the blanks. And you've cited some cases for that proposition, but as I read those cases, and those arbitration agreements specify that Florida law applied. So how do you bootstrap the Florida Arbitration Code into this agreement so that it can then supply the missing terms? And I think that's your argument. If I'm wrong, please clarify for me.
It's not, that's essentially my argument, Your Honor, but it's not a question of bootstrapping. The agreement says that this could, the arbitration can be brought in, or the substantive law that would control would be the control of the law that would control if the claim was brought in federal court where the facility is located. That's Florida.
Well, that says adjudicated.
But that's Florida law.
I'm sorry, I interrupted you. That says adjudicated. Is that the same as interpreted? I mean,
well, there's no suggestion here, Your Honor, that there's a federal, federal question or that there's diversity of citizenship. But if there were, it would be, you would be adjudicated. Well, I mean, the only place that this case could be adjudicated, if it were going to be adjudicated in, it would be in federal court here in Florida. We address in the brief this.
Well, it could be adjudicated anywhere, couldn't it?
Well, Your Honor, actually, you raise a good point there, and it kind of, as I was talking, it kind of occurred to me as well. But you'll recall that we talk in our brief about the fact that the contract, the principle of the contract is governed by the law where it's executed. The facilities in Florida, all the parties are in Florida.
Right, you argued that, I think, in your brief.
Yes, Your Honor. So, I mean, everything about this says the location where we're going to arbitrate this is going to be Florida. And the location where it would be adjudicated would be Florida. So the law that's in control here is Florida law as a default. And I'd point out to the court also that earlier in the agreement, in the first part, the mediation part of the agreement, it says that the mediation shall be conducted pursuant to the rules and procedures of the American Arbitration Association for the resolution of disputes. So I think that while it's not, right, maybe a little sloppy, what they're saying is that the AAA rules are the rules that apply here. The American
for a mediation,
Association.
For a mediation. So we have to then, again, there is a lot in this agreement that requires fill in the blanks, apply your common sense. Oh, look over here. I mean, there's a lot wrong, technically with this agreement. Whether it's enough to invalidate it, it's a different question. But a theme of your argument is it's clear the parties, this is about an arbitral forum. That's the heart of this agreement. But they didn't include all the terms. Like how much could they have cared about it when they leave all these blanks?
Well, Your Honor, that really the plaintiff's argument was, and I think they did a good job sort of muddying the water. To say, wow, there are a ton of issues here. There really aren't a ton of issues. There are a couple of issues here, which can be addressed either by severance or by using the default provisions of the revised Florida Arbitration Code. I mean, the legislature, when it passed the revised Florida Arbitration Code, recognized that there would be cases where there would be some, there would be some gaps or there would be some ambiguity. So they provided an entire set of default provisions and default rules that would govern. And if this were litigated in federal court, and that would presume that the FAA was applicable. The FAA would also, this agreement would also be one that could be upheld under the FAA. So, I mean, when we look at this, so we talk about all the fill in the blanks that there really aren't that many fill in the blanks. I mean, we have an agreement to arbitrate. We know who the parties are. We know which claims are covered. We know there has to be a single neutral arbitrator. we know that if the law that would be applied would be the law that would be applied by U.S. District Court sitting at the place of the hearing. There's no way that this case would be, the hearing in this case would be anywhere other than Florida. So if we had a forum selection clause that put us outside of Florida, then it would be invalid. So the place where the hearings are going to occur here is undoubtedly Florida. Everything about this case is Florida. So the provisions that have to be filled in, to the extent there are fill-in provisions, are actually relatively minor when you boil them down. And they're exactly the kinds of provisions that the revised Florida Arbitration Code was meant to fill in, so that parties' intent to arbitrate and the state policy in favor of arbitration could be upheld in cases like this. This agreement certainly is far from perfect, but perfection is not the standard. And when you look
Mr.
at
Valdez, this court has addressed this issue of severability and enforceability of arbitration clauses many times. You've cited a number of the cases. The Hochbaum case decided in 2016. I believe Judge Kelly was on that panel, as a matter of fact. 2D19-47 Voorhees case decided last year. The Spring Lake case, which was my case quite a few years ago. I'm wondering if there's any of these cases that you would particularly point this court to as being persuasive under the facts that we are presented with here in this one.
Well, Your Honor, I think that I think the one that's the most persuasive, and that's probably because it's the most recent, and so is a sort of a compendium of the court's rulings on the issue, is the 2D19-47 Voorhees Road versus Tesorero case. That case involved both limitations of damages and a fee shifting provision. And in that case, the court really walks through, very nicely, having the benefit of your case, having the benefit of Judge Kelly's prior case and a number of other prior cases, walks through the analysis that should apply in cases like this one. You could virtually, you could put the facts of this case into the Tesorero opinion, and all of the analysis would hold true to the extent.
Mr. Valdez, if you'd like to say, I'm sorry to interrupt. There's this lag. I'm sorry.
That's no problem.
I just want to let you know you still have some time for rebuttal if you'd like to save it.
All right, I would, Your Honor. So under the controlling case law discussed in great detail and sort of in a compendium in the Tesorero case, I think that that case is as strong as any for us. But I think really all of the cases that we cited in the brief from this DCA and the other DCAs talk about severance of problematic provisions and resolution of ambiguities. As in this case, I think it was the Figueroa case, that where the any ambiguity is resolved in favor of finding that arbitration should occur in accordance with the intent of the parties and the Florida policy in favor of arbitration. I'll reserve the remainder of my time for rebuttal. Thank you.
Okay, thank you. Whenever you're ready, counsel.
Thank you. Good morning. Lisa Tanaka for the estate of Doris Piscazzi, the appellee. May it please the court. The trial court correctly ruled that this arbitration agreement is enforceable. And as Your Honor, Judge Kelly pointed out, this agreement has a lot of flaws. And this court has heard and read the appellant's concessions that it does contain flaws. And also—
Ms. Tanaka, let me jump in for a minute. There's no question, and I read the entire 2 days worth of hearings that were addressed at each and every, I think your firm, or I don't think it was you. Was it you that argued it, or whoever argued it, did a nice job of pointing out basically all sorts of things that shouldn't be in there, or are misleading or confusing. But I am somewhat persuaded by the case law over the years that that where there's an agreement between parties to arbitrate, and where there is a fairly comprehensive severability clause, as there is in this case, that the tenor of these cases is that we typically enforce the arbitration clause because whatever is offensive can be severed out. So I'd like you to tell me that why can't, for example, in a case like this where the claim was filed within a year, why isn't the severability of that particular illegal provision an acceptable way to handle the problem? And in addition to that, if this kind of compound, are there any of the other things that were brought out that don't fall into that same category that, well, okay, if that's confusing, let's just sever it. At the end of the day, the point is that these parties agreed to arbitrate. Nobody forced them into it. There's no suggestion that there was any sort of high pressure tactics or time limitations placed on the signing of the agreement. So why shouldn't we, under our case law, take paragraph 18, the comprehensive severability, and just take it wield it like an axe and chop out the bad stuff, and we're still left with an arbitration?
There are multiple reasons why we can't just sever. The first reason is severing the offending provisions does not cure the fact that this arbitration agreement is missing essential terms. In order for contracts to be valid and enforceable, at a minimum, they must include essential terms. And the Florida Supreme Court has made clear that the arbitration rules of procedure is an essential term in an arbitration agreement. In fact, this court has reiterated that requirement numerous times. In the Davis case, which Your Honor, Judge Black was on that case, this court quoted its prior decision stating that there can be no quarrel that a contract cannot stand if it is missing essential terms of an agreement. Essential terms of an arbitration agreement include the form and procedure for arbitration. And where the terms are not—
Well, Ms. Tanaka, for example, you make a whole lot out of the whole rule, the rules and the provision that says the rules will be available from Article 8. But I think your opponent basically has two positions on that. One is there's no real contention that the rules weren't available and available in multiple places. And also that the arbitration, probably more importantly, that the arbitration code, which was in effect before this agreement was signed, by its text, the statutory text of the Florida Arbitration Code, applies to this agreement. So, to me, the material term of an arbitration agreement is we hereby agree to arbitrate. And there's consideration expressed and other agreements. And to me, a lot of the arguments that you've made either build a bunch of sort of small technical errors or pertain to things that are not material to the fundamental agreement, which is to arbitrate.
So the appellants do suggest the gap filling, using the Florida Arbitration Code as a gap filler for the missing arbitration rules of procedure. And that suggestion has been addressed numerous times. In fact, to this court directly in the Davis case. In the Davis case, that same suggestion was made by in that case, it was a nursing home arbitration agreement that the trial court had found was enforceable. And the resident's estate appealed that decision on the basis that it was missing essential terms and it therefore should have been held unenforceable. And the nursing home appellees argued the same argument that this panel is hearing today, that there was clear intent from the part of the agreement that was in evidence that the parties intended to arbitrate their disputes. And therefore, the court should uphold the enforceability and could use the Florida Arbitration Code as a gap filler for this missing essential terms. And during the oral argument in Davis, it was coincidentally Chief Judge Davis, who acknowledged that the part of the arbitration agreement, which was the signature page, that was the only page that was in evidence. But Judge Davis acknowledged that that was sufficient enough. And it was, he actually stated it was one of the more explicit signature pages that he had seen to these agreements that showed the intent of the parties was to arbitrate. In that case, the signature page indicated that the resident had signed the arbitration agreement, that she had read the arbitration agreement, that she—
What year was the Davis case decided in?
That case was a 2015 case.
And what was the operative year for the arbitration agreement? Was it before 2013?
I'm sorry, I do not recall that, the operative year on that.
Because that would make a difference.
Well, the court looked at a number of, looked at that case. I also looked at the Spicer opinion, which came out just prior to the Davis case. And the question with regards to why can the Florida Arbitration Code not be used as a gap filler that Judge Davis posed to the nursing home appellees in Davis, the answer and the reasoning to that question is equally applicable here. And that is, in order for the Florida Arbitration Code to be used as a gap filler, the arbitration agreement still needs to say that Florida law applies.
I disagree with you. The legislature, in I think it was the 2013 amendments or revisions to the arbitration code, says effective now, this code applies to all arbitration agreements in Florida. And so I'm going to need you to reconcile that for me.
Well, I think that the matter of contract law is—
No. I'm talking about a matter of statutory mandate.
So if based on Your Honor's interpretation, if the Florida Arbitration Code could encompass the and be used as a gap filler, the other problem that
Well, wait, let's back up. The Florida Arbitration Code applies to this agreement. You agree with that, don't you?
Respectfully, no.
Why not?
Because the governing law in this arbitration agreement is not Florida. There's a provision—
What governing law is it?
Well, there's a provision in the arbitration agreement that actually is entitled governing law. It's
right, and it's incomplete. So this isn't governed by the law of Pluto, and everything that happened in this case happened in Florida. And your position is that the Florida Arbitration Code doesn't apply?
Correct, Your Honor. I believe that the arbitration agreement as a contract at the time that it was created, and if we're looking at the interpretation or the enforceability of this contract—
Is it your position that no law applies to this agreement because it doesn't specifically invoke the law of a particular jurisdiction?
It is that the—
Well, then that's preposterous. There has to be a governing body of law, regardless of whether the agreement says or specifically states what the parties have chosen.
So the agreement in this case does not define or does not designate clearly which law should apply. The parties did not—
And you're going to argue that Florida law doesn't apply?
I'm arguing that the agreement does not designate that the arbitration should be—
But that doesn't mean that Florida law doesn't apply.
Florida law applies to determine whether this contract is enforceable, but it is not the governing law of the arbitration as designated in the agreement. This is a contract between parties, and the parties could theoretically choose any law to govern.
But they didn't, and some law applies.
Correct, but—
And since nobody lives anywhere but in Florida, and everything that happened in this case happened in Florida, I'm struggling with what the law of what jurisdiction or what tribunal you're going to suggest would apply in lieu of Florida.
Well, our suggestion is that the agreement actually is unenforceable. And the second reason why the arbitration agreement Well, in fact, going back to the essential terms, the Florida Supreme Court has held that the rules of procedure is an essential term. And so what
Let me stop you right there. I want to jump in. It's my turn to ask a question. On that point about missing essential terms, because I think that's, one of your more persuasive arguments. However, if we were to find that the Florida Arbitration Code did govern this agreement and could provide the gap fillers, what does that do to your argument that this agreement is missing essential terms and therefore a valid agreement was never formed? What essential missing terms would there be if we did look to the Florida Arbitration Code to fill the gaps?
So the problem with, even if we, in your honors, I'm going to call it a hypothetical for the purpose of answering the question. If the Florida Arbitration Code was hypothetically be able to be used as a gap filler pursuant to the law, then I would direct the court's attention to Section 17 of the arbitration agreement. Section 17 is the modification provision. And what this section states is this agreement can be modified only by writing signed by the parties.
Well,
so the introduction of,
I'm sorry, I'm going to just stop you. I understand that's your argument. I don't mean to be rude and cut you off, but I think the modification provision is if the parties want to modify it, not if a court is interpreting it or modifying it.
well, respectfully, Your Honor, the problem.
I mean, if you have some case law that says that governs a court's ability to modify an agreement, then point it out, please.
I don't have a case, but I respectfully want to distinguish that interpretation that that Your Honor is stating. If the parties were to modify, then the modification would need to be agreed in writing, signed by the parties. But the court could modify without that. That is a different way that the contract could have been written than what we have here. What we have here is that all modifications, this agreement can be modified only, and the key term there is only by agreement in writing signed by the parties. And then if we look at Section 18,
okay, so I guess let's follow that thread then. So we can't modify, as a court, we can't modify this like under the severability clause. We can't do that unless both parties sign off in writing. So then we can't fill in the gaps. So that's what you're saying? Is that where your argument's going? We can't modify it unless everyone agrees, so therefore the agreement's going to fail?
correct, Your Honor.
Okay.
And in fact, the severability clause in this case, in number 18.
I mean, because the severability clause says a court construing this agreement may modify or interpret in order to render it enforceable.
Correct, Your Honor.
So the severability speaks to what the court does. This term modification and revocation speaks to what the parties are able to do. Like the court can't revoke it. We can't say, oh, we're revoking your contract.
Well, and that's the distinction, that if that was the interpretation of the parties, then the contract should have been written that the parties can modify only by writing signed by the parties. The court can also modify, but that's not what it states. It states here that the court can
Well, it says the court can modify it in the next provision under severability.
Right, but if we go with that interpretation, then that would render the section 17 that the agreement can only be modified in writing by the parties. That would be rendered meaningless. And of course, we cannot.
Why would it be meaningless? It deals with two different situations, what the parties can do and what the court can do.
Right. It still
well,
governs
that's not what the agreement says, though. The agreement doesn't.
That's exactly what the agreement says.
Well,
it says the parties can modify it and a court can modify or interpret it.
Well,
Those are the two different provisions dealing with two different situations.
respectfully, Your Honor, the modification provision does not say the parties can modify only by a
Well,
writing.
because it's written in the passive voice, but it clearly contemplates the parties signing a modification agreement if they decide to modify.
Well, that's an interpretation that when we're looking.
Do you have a passive voice canon that somehow turns that modification agreement into governing also the severability provision that lets us interpret this differently? Because my understanding of the canons of interpretation are different subject matters, different actions, among other things. And that seems to apply here.
Well, I don't have a canon. I do believe that the way that the arbitration agreement is written, like any other contract, it is important to look at the words and the interpretation, as Your Honors have pointed out, of numbers 17 of the arbitration agreement can be interpreted. It could be looked at one of two ways. Either the agreement can only be modified by a writing signed by the parties, or the parties can interpret or can modify the agreement by writing signed by the parties. And my argument is based on what is written in this contract. And if the argument that I was alluding to, if we look at what is actually written, while it is in a passive voice, this agreement can be modified or revoked only by writing signed by the parties. If we take that for exactly as it's written, then to allow a court to modify, which is what Section 18 states, modify by severing without that writing would render that term only as written meaningless. Of course, we can't do that.
But you would agree that paragraph 18 doesn't require another writing signed by both parties, wouldn't you?
If it was written, if this.
Well, no, I'm talking about the severability. You're saying that we basically have to do a mashup on this to arrive at how this court can interpret the agreement. And what I'm saying is, to modify, the parties have to sign a separate document under paragraph 17. Under paragraph 18, the court construing may modify or interpret, and it doesn't say anything about a separate writing signed by both parties.
And I would agree with Your Honor that Section 18 does not state anything with regards to signing a written agreement.
And I'm just trying to draw, we're talking about words matter, and I'm trying to point out the distinction between the operation of these two provisions as it appears to me. So tell me how which part of that I've missed.
So as I stated, I agree with Your Honor that 18 does not mention anything about a signed writing. However, we have to look at all the terms of this contract, and each term must be given meaning where meaning can be given reasonably. And here, when we just do a straightforward reading of these two provisions together, it states that a court may modify in order to render it enforceable only if there is a writing signed by the parties. That gives meaning to both. Alternatively, these two...
To me, and respectfully, that renders both provisions meaningless. Because if the only way the court can modify it is after your client signs off on the agreement to the construction that you're advocating here, then paragraph 18 means nothing.
Well, the way that the language would read is that the court could modify if there's an agreement in writing by the parties. So, for example, if after the arbitration agreement was signed a year later or 6 months later, the parties put in writing that they agreed to sever some of the terms, they wanted to modify the agreement that way. And we are here today arguing whether that modification that the parties agreed to could be severed, then arguably and theoretically that this court would have, or the trial court would have had the authority under the terms of the arbitration agreement to sever. But we don't have that.
You're almost at the end of your time, but I want to sneak in one more question. In reading over the transcripts of the two hearings, a lot of the argument was particularly at the first hearing, was directed to, well, this provision's ambiguous, this provision's vague. Does vagueness or ambiguity in and of itself render a provision either unconscionable or against public policy? Is that your position?
I think it depends on which provision it is.
Well, just in general, if the only thing you say about a provision, oh, this provision, it's vague or it's ambiguous, just in general, does that make it against public policy or unconscionable?
I think if the term is not essential, then arguably, if that is the only issue, then it's not necessarily going to be against public policy.
Because,
it
well,
could be
okay,
unconscionable.
and let me just follow up, because my thinking is, okay, if you find that this, yeah, there are problems with this agreement, but if you can find that the arbitration code applies and, you know, close enough, it's a valid agreement, it's got all the essential terms, there's nothing against public policy, it's not unconscionable, we're going to send it to arbitration. Can't the arbitrator, isn't it the job of the arbitrator to then sort out what ambiguous or vague terms mean?
For this situation, in this case, no. It is the court's role to determine whether this agreement is a valid and enforceable agreement. And if there are terms that are vague or ambiguous, they go to the unconscionability of the agreement, or they are void against public policy, then the agreement is rendered unenforceable unless they can be severed. And
okay, all right, I'm sorry, that's a good enough answer for me, and you are at the end of your time.
Okay.
Thank you very much.
thank you.
All right, Mr. Valdez.
Your Honor, the last word I have on severability, the last sentence of that provision, severability provision, says if any provision of the agreement is adjudged to be void or otherwise enforceable in whole or in part, such adjudication shall not affect the validity of the remainder of the agreement.
Actually, Mr. Valdez, I was focusing on the first sentence of paragraph 18, which in my interpretation is just, it's pretty simple. This contract gives this court the authority to modify or interpret this agreement to make it enforceable. We are granted the authority to make that interpretation as I read it. It seems pretty clear to me.
Yes, sir. I agree. I agree 100%. And with that, I'll move on to.
Both parties have signed an agreement indicating they want to arbitrate, and this court is given the authority to make that almost, that may be overstated a little bit, but to make it happen, to do what we have to do to make it, to render it enforceable.
You're 100% right, Your Honor. I agree completely. And with that, I'll move on to the other issue. This contract is not missing any essential terms. When you look at the terms that are in the contract, and you look at the issues that Judge LaBritte talked about, some technical issues, some of which, a lot of which, in fact, are immaterial. It's not missing any terms that cannot be addressed by the gap filler provisions of the revised Florida Arbitration Code. The Davis case that opposing counsel cites and relies on heavily was decided under the prior version of the Florida Arbitration Code. This case is governed under the revised Florida Arbitration Code, which specifically added these gap filler provisions, and in essence eviscerates plaintiffs' absence of essential terms argument. Florida law controls here because the law applied by a U.S. District Court sitting at the place of the hearing. And again, everything in this case has happened in Florida.
Well, does it say the state court or the district court?
Law applied by U.S. District Court sitting at the place of the hearing. Well, unless I'm misreading that, but to me, the most important part is that is the place of the hearing. The place of the hearing is Florida. Everything has happened in Florida. The contract is formed in Florida. The facilities are in Florida. The parties are in Florida. The place of the hearing is Florida. Florida law unquestionably.
It says in accordance with state or federal law, which would be applied by a U.S. District Court sitting at the place of the hearing.
The place of the hearing. And
So
again,
state or federal. Which would it be? Or
well,
both?
it says state or federal because to the extent the federal arbitration code applied, it might, it might govern certain aspects of the case, but substantive law under the FAA is the law of the foreign state. So substantive
So
law.
that
here is
means if you were
unquestionably
over in the middle district and they were going to apply state law, that's the state law we'd apply. If it was going to apply federal law, that's the federal law we would apply, whatever the middle district would do.
No, Your
Is that
Honor.
what that means?
No, the middle district would, if we're not really we haven't focused at all on the FAA or its applicability here. I think it could be, but to the extent that the middle district was looking at this, it would interpret.
No. You're the arbitrator. You're the arbitrator, and you're like, okay, what law do I apply? So you look at this governing law. What law is the arbitrator going to apply?
They're going to apply Florida substantive law.
Well, the arbitrator is going to have to figure out what the U.S. District Court would apply, right? And then apply that.
And the U.S. District Court, sitting in a case that's governed, even if this case were governed by the Federal Arbitration Act, that in and of itself is not enough to grant federal question jurisdiction. This case could only be before a federal court if there was diversity jurisdiction or diversity jurisdiction.
The arbitrator gets to sort all that out, and the parties can just argue to the arbitrator about whether it be state law or federal law and what the middle district would do.
That's correct, Your Honor. And what these parties will argue, my parties will argue, is, as we have from the beginning, is Florida substantive law applies. There's no basis upon which any other substantive law could
I mean,
apply.
the fact that this goes back to my question previously, the fact that this provision is confusing or vague or ambiguous, isn't that something that the arbitrator can sort out? I mean, it does.
To the extent that, yes, Your Honor.
I mean, you're trying to argue, oh, it's perfectly clear. I don't think it's perfectly clear, but I don't know that makes it against public policy or unconscionable as much as it presents an issue to the arbitrator that the arbitrator is going to have to sort out.
I agree with Your Honor that the majority of these issues, to the extent there's any lack of clarity, would be resolved by the arbitrator. But I think it's unquestionable based on the facts of this case that the Florida substantive law is what controls. There's no argument that I could make that any other substantive law would control.
No, that's not my point. I don't really care about what law applies. I care about, you're the arbitrator and this case lands in front of you and you got to figure out what law to apply.
Then I think that that Florida law is that law. That's what for the arbitrator to do. And I'm saying on the record, we would not take a position contrary to that. We would not tell the arbitrator, will not tell the arbitrator that anything other than Florida law applies. So we've told the circuit court and this court, we can't possibly in good faith say anything else, nor would we. Florida law applies. The Florida case law and the revised Florida arbitration code combine to give us an agreement that with possibly some tweaks as the court sees fit, if the severance, for example, of the provision that Judge Kelly was focused on at the beginning, we have a valid enforceable arbitration agreement.
All right, sir, you are at the end of your time.
Thank you, Your Honor. For those reasons, we'd ask this court to reverse the lower court's decision and remand with directions to refer this case to arbitration.
Thank you all both for this interesting argument about an arbitration agreement. They aren't always. Thank you. All right, our next case this morning is Henry versus Efficient Home Services of Florida.